checked with DCMS, and there is, as my Lord Carnwath indicated, he'd not seen any policy on how the Secretary of State or Historic England approached building, and it's right that there is no policy guidance per se on that other than what you've already seen.
Thank you.
I was going to turn, having looked at the matters that I started with in terms of the statements of principle about listing deriving from, whether something was a listed building deriving from the list itself, to the issue as to how this question can be raised and determined. And it's dealt with to a large extent in our printed case, but I'll pull out the salient points. It starts at page 118, paragraph 59, under the fair opportunity to challenge. The first point of importance, which the court will have seen from section 1, is it is the Secretary of State in England, the Welsh ministers in Wales, who make the decision, albeit on advice, whether or not to list and whether or not to amend the list. So even if Historic England has conducted a review or a delisting exercise, it's still a recommendation to the Secretary of State in order to make the decision. So it's for the Secretary of State to act lawfully in compiling or amending the list. And to turn Learned Friend's point around, this is not a simplex type case of would it have been determined to be a building in any event, although I maintain what I said before lunch. The Secretary of State, having listed it, it would be for my learned friend in challenging it to show that no reasonable Secretary of State could have considered it appropriate to list the items in question.
Is that the correct test?
Yes, I'm surprised you say that.
It's surely the question of what is a building is a question of law, and therefore it's almost like a precedent fact. You've got to show that the term is fulfilled.
I'm sorry, I don't dissent from that.
Thank you.
But I would go further than that and say that it's a question of mixed fact and law.
Indeed, it's mixed fact and law. Unlike the issues, the point being, it's unlike the issues which are left on appeal, which are only the issues of expert judgment we submit, based on whether the building retains its special historic or architectural interest. The Ground A appeal is directed to the expert determination of the significance of the item, not to the validity of the listing in the first place. I'm going to go through the statute.
The merits as opposed to the validity of the listing.
Indeed.
But, I mean, could you put it this way, that the fact that we have this list in section 38 indicates that Parliament thought that the question, is it a building, that question, mixed facts and law, I accept, should be dealt with outside the appeal process.
That is precisely my submission. Just as in the Wicks case, which was a general planning enforcement notice case, Lord Hoffman, having reviewed comprehensively the enforcement provisions in the Town and Country Planning Act, which mirror these to a significant degree, though there are some major differences, the grounds of appeal issue and the preclusive clause issue and prosecution for breach, though that structure still applies as it does in listed buildings, he concluded that residual matters, as he called them, matters which were not covered by the grounds of appeal, even in terms of the ability of someone to raise matters by way of defence on a prosecution, were properly matters for judicial review. And the references are in Lord Justice Hickenbottom's judgment in the Court of Appeal and in our case.
But I mean, I don't know whether you're going to Wicks, but
yes.
If one looks at page 662, this is bundle 2.
Yes, I've got the wrong bundle.
22.
Sorry.
Bundle 2, 22, page MS 662.
Yes.
He says there that no hardship will be caused because he says the statutory grounds of appeal are so wide they include every aspect of the merits of the decision to serve an enforcement notice.
Yes, merits of the decision.
Well, the merits, so in fact everything that someone want to raise except questions of bias and those sort of things.
Well, and
surely the question of whether something's a building is very much part of the merits of the whole process.
Well, I don't accept that, my lord, and I'll explain why in a moment, if, with respect. What Parliament, we say, has done is it's created a complex but clear structure which leaves the initial decision to list with the Secretary of State or to amend. That, as has been pointed out, is a discretionary decision which can be revisited by the Secretary of State at any time. Section 1.1 is not confined in any way in terms of when the review can be triggered. A party can raise a challenge to that at the time of listing. It can request a review from the Secretary of State at any time. In terms of the listing being reviewed, the Secretary, I'm afraid it was omitted from my cases, but it struck me as obvious yesterday when I was looking at the Historic England delisting advice. The Secretary of State has guidance, which the court might want to see, allowing a non-statutory review of the listing within 28 days of the listing itself. I appreciate it doesn't apply in this case because listing occurred many years before the issue of the sale, but the court might wish to know that the Secretary of State operates a non-statutory review mechanism. Can I have that circulated? If that's
Thank you.
acceptable?
Yes, of course.
I've got I don't know whether the court wants both of them. I've got the current version, which is currently found on the website. I've got the version that was in force at the date of the sale as well.
What do you recommend?
They say virtually the same thing. Shall I give you the version in force at the time?
Very well.
But there is an up-to-date list.
Thank you.
The substance of what I'm going to tell you remains the same.
Thank you.
Thank you.
Thank you.
Thank you.
And this was the guidance. It was promulgated in 2009, and the Secretary of State has an informal policy which works a little bit like Section 2D in Wales, only without the ability, without the requirement for hearings and the like. It's much more general process. But you'll see there's a process for completing a review request, and they should be submitted within 28 days of the decision letter. This is under Section 8 from English Heritage, which is the letter notifying the owners of the listing decision. Details of the building must be provided, and then D&E, your grounds for requesting a review, and it states in the second sentence, Secretary of State will only review listing in certain circumstances. A review will be carried out if there's evidence the original decision has been wrongly made. Examples would be where there's been a significant factual error, wrong building were listed, or I might say it's disputed that it's a building at all, where there has been some irregularity in the process that has affected the outcome. There's then a passage which reflects the delisting guidance in the Historic England document, which is new evidence to show that the judgment on special historic or architectural importance should be revised. But it's clearly non-statutory guidance as to how the Secretary of State will allow an instant review of listing, which will include irregularities in the original decision to list.
That would include whether it was a building or not.
Yes, it would. Yes, it would.
So, how does the listed person get this?
The listed person is told of the listing.
I thought he was told of the listing by the local authority, but this says a decision letter from English Heritage.
The department instructs English Heritage, now Historic England, which is the advisor that recommends the listing in the first place in most cases, to send out the letter with the listing details. And indeed, it's Historic England now through its website, which compiles the national list, which can then be searched.
So what, they send this to the authority, and the authority sends it to the...
Can I check? The decision letter informs the owner of the review policy.
But are you telling us that English heritage right direct to the landowner?
Notifies the landowner, and
Because I think we were shown provisions which said the local planning authority did
I
that.
think it's a question of
Has it
practice.
changed?
It's a question of practice rather than the legal duty.
Right. So
Mr. Relvin, we must get this clear. Who sends the letter? We thought it was Stratford that should have.
My understanding is that there's a practice that the owners are sent it directly, but I'm going to check.
May have changed since this.
yeah,
particular
right.
case.
I'm sorry, madam?
May have changed since this building was listed, this thing was listed.
The department informs Historic England. Historic England sends out letters to the owners and to the local authority.
And so is the local authority then also bound by its statutory duty to send on the letter, even though
Yes, but
it'll be
it's a
received
matter of
once?
practice. And indeed, I'm told that although in many cases owners aren't informed, there is, in some cases where there isn't a risk of preemption, owners are sometimes consulted or informed that the consideration is being given to listing a particular item, so that owners are not always kept in the dark until the letter saying it's been listed arrives.
And do we? Oh, I'm so sorry.
After you.
Do we know whether that was the practice at the time that this item was listed?
If you'll forgive me.
Yeah.
I can't say.
No. All right.
So the owner gets two letters, one from English Heritage and one from the local planning authority.
And it goes.
Is that right?
Yes. And it goes on to the statutory list. I'm sorry, it goes on to it going onto the statutory list is reflected in the local land charges register.
So here, poor Mr. Dill got letters from no one. But
Sorry?
Mr. Dill got letters from no one in this case. But
The evidence is unclear. What Mr. Dill's evidence says is that he understands his father wasn't aware that it was a listed building. We simply don't have any detailed evidence from that time on one side or the other, and certainly we're not suggesting one thing or another. Simply, that's...
And when we read on this bit of paper, completing the review request form, would it be helpful for us to see the review request form?
I'm not sure. We have multiple copies, but it can be sent.
Would it be helpful for us to see
I don't think it makes...
to see exactly what can be requested?
I have my own copy with me. I can tell you what it says.
Would you like your solicitors to get that copied 5 times for us?
Yes. Or would you like to receive it electronically, my lord?
I'd prefer it to be copied this afternoon 5 times for us to have it by 4 o'clock, if that's not too much to ask.
No.
Thanks very much.
I mean, this is non-statutory.
This is
Probably wasn't in force at the time we're talking about, and it doesn't really help on the legal issues.
It only goes to the general questions. It doesn't help with Mr. Dill's specific circumstances.
Yes.
Secondly, of course, when the question of a review arises, you've seen, and it's in the bundle, the Historic England Guidance on Delisting, which largely focuses on the historic or special architectural importance. They will recommend to the Secretary of State if the listing should be reviewed or the building should be delisted. But equally, at all times, there has been information available from either the local authority or Historic England as to whether a building is listed. So if there's any doubt over whether an item was listed, you could always seek information. And the online service that I've referred to was only made available in 2011. There were earlier online services that preceded it. And there's a duty in Section 2, in any event, for written copies of the relevant part of the list relating to a district or county or London borough to go to the relevant local authority and to public libraries so that they can be consulted.
But I mean, if you don't think that the object is a building, you wouldn't have reason to consult the list.
I don't want to make submissions that appear to be going behind the point I made earlier, but if one has some substantial items of urns on piers 9 feet high of some antiquity, which warrant the sort of payment being sought that was made in this case, one might have thought it was prudent to check the list. I don't criticise Mr. Dill. There's no evidence on which to do so, and I wouldn't seek to do so, but it is always open to a landowner in any case of doubt to check. And the fact that it's on the planning register as a local land charge is also a relevant consideration. You can ask the local authority.
Right, but again, if you're not selling your property, you wouldn't have particular reason to be looking at the land register day by day.
No, but similarly, you may not be aware, and there'd be no reason to criticise the listing, and the same point could arise. Ignorance, of course, not being generally a matter which allows one to avoid the consequences. So there's ample scope for making inquiries. The Secretary of State can be asked to amend the list at any time in any event. The question then is, well, what did Parliament do in its structure, in particular the grounds of appeal for listed building consent and for enforcement notices? And if I could ask the Court to go back to the Listed Building and Conservation Areas Act. Can I deal firstly with section 39, page 303? We do submit that my learned friend's submissions are wrong, that A and C encompass whether the listed building is a building, because the purpose of A, which is clear from its wording and the structure of the provisions, is to allow an inspector or the Secretary of State on a listed building enforcement notice appeal to review the question of special architectural or historic interest. The ground is not that the building should not be a listed building, but that the building is not of special architectural or historic interest. And that's the basis upon which an inspector is then given delegated power, should he reach that conclusion, to recommend the amendment of the list under the provisions of Schedule 3 that you've seen. B is the matters alleged to constitute a contravention of Section 9, and then the contravention in C is clearly the contravention of Section 9, 9.1 in this case, as my learned friend has pointed out. Section 9 proceeds on the basis that the building is a listed building because it appears in the list, because that's how Section 1.5 deals with it. And Section 9, if the Court would go back to it at page 282, deals with a contravention of Section 7, but it's also said in 2, in relation to conditions, and you'll see that it's using the defined term listed building, not just building, and listed building, of course, is something that appears on the list, the opening phrase of Section 1.5. So we say...
But Section 1.5, in this Act, listed building means a building, which is for the time being included in a list.
Yes.
So you need two things. You need a building, and you need its inclusion in a list.
Yes.
You're eliding the two. And you're saying inclusion in the list eliminates the need for a building. But it's got to be a building.
No, my lord, I'm not. It flows from what I was saying before lunch. And what I've just said is the Secretary of State's decision whether or not a matter is included within the list. That's open to challenge. What is a listed building is something that appears in the list, hence those references I drew the Court's attention to before.
No, but it's also, sorry, surely my Lord's point is it also has to be a building. You say, what is a listed building? It's what appears in the list. It's a building that appears in the list.
Yes, and
that
goes to the question of the decision in the first place whether or not to list it.
Right, but surely, why doesn't it go to whether there is... looking at section 7.1, works for the demolition of a listed building. If it's not a building, it cannot be a listed building.
Well, the structure of the Act, as has been referred to in those other authorities that I mentioned before lunch, is that there is a clear and straightforward answer to the question of whether something's a listed building, which is you look and see whether it's in the list. And that the question of whether it's been properly included within the list for reasons other than special architectural and historic interest is a matter for the Secretary of State and for any challenge to be made at the relevant time. And that is supported by the fact that ground A plainly averts only to special architectural or historic interest as being the reason being the ground of appeal, because why say not a special architectural or historic interest if it also encompasses other issues?
Okay, so can I, just putting enforcement to one side for the moment, suppose a prosecution of an offence charged under Section 9 read with Section 7. Would the accused be able to defend themselves by saying, in fact, this is not a building?
Well, the learned friend says not. In paragraph 73,
I said yes. He
said orally not. Paragraph 73 of his statement of case suggests that he couldn't raise it in a prosecution.
No, I think in answer to my Lord Kitchen, he said that...
Anyway, what do you say?
Yes, quite. That was my question as well.
I'm prepared to answer. Well, on the authority of Wicks, the suggestion, the answer would be no. That's a matter of judicial review.
What does Wicks say about this?
Wicks says that prosecution is part of the code for enforcement and therefore should be read as subject to the same strictures as the remaining provisions.
But I mean, the sort of things you can't raise in Wicks were completely different from this. They were questions of bias and so on.
Well,
no suggestion you couldn't raise a basic issues whether this is a building.
Well, the problem is this, my lord. If issues of the validity of the original decision to list can be raised, why should they be restricted to issues of whether it's a building or not? If you can raise as a ground of appeal that it isn't properly listed, it would be odd to restrict that to the question of simply whether it's a building. What if there was some other procedural defect?
I mean, what about whether the object was placed there after July 48 and therefore doesn't come within the extended definition?
Well,
Can you raise that on?
Well, that's like a construction of a planning permission point, which an inspector may have to grapple with to decide whether or not there's a breach of an
Under which ground in 39 would that come, and could you raise it in defence or prosecution?
Well, you would say it doesn't fall within Section 1.5 because it doesn't fall within. It's not the listed building.
Which of the grounds in Section 39 would it come on?
Can I answer it this way? You can't answer the question of whether it's a curtilage listed item or whether it's an object or structure fixed to the building simply by reference to the listing itself, because they are applied to the listing.
No, I understand
by
that.
A and
Could
B.
you raise it by way of an appeal, and if so, under which ground?
Well, you'd say it wasn't a contravention because it doesn't fall within 1.5b. That's not to say that the listing's invalid. It's simply to say that the listing does not extend to cover it. It's the issue of scope which the Court of Appeal distinguished from the issue of validity.
I mean, funnily enough, I mean, if you were to persuade us that it's not open to an appellant to say it's not a building, we want to argue that it's not a building, you might be forcing us to say that it would be something that would have to be raised in the criminal proceedings. And that wouldn't be at all satisfactory, Mr.
Well, my Lord Carnwath's answer to that in the Trim case, where there was no right of appeal in the first place, was to say, well, you can't assume that this necessarily leads to a prosecution.
Well, I think if you want to rub my nose in Trim's case, you better take
to
it.
rub your nose in. I've got copies of it, and I'll have.
No, I mean, you know, but if it's relevant, do so. But I think you should answer my Lord's question first, without regard to my authority.
Applying the approach of Lord Hoffman and Wicks, and I think I need to take you to Wicks very shortly. The approach to raising public law issues in this way is Lord Hoffman said, to go by way of judicial review. And therefore, if there is a prosecution, you bring a you seek judicial review, or you seek to forestall it if you think a prosecution's in the offing, by raising the issue directly with the Secretary of State, and if he refuses to deal with it under Section 1, judicially review that.
But the question whether it's a building isn't a public law issue. So going back to Section 7.1, it uses the concept of listed building, which, as my Lord says, has two elements to it. It's both a building and it's listed.
Yes.
Now, the listing is an administrative act governed by public law.
It is.
But whether it's a building is a matter defined by the statute and governed directly by the statute.
That is true, but it's a mixed question of fact and law.
Right.
Yeah. And what has been said in previous cases, Shimizu in particular, is you have to draw a distinction between the application of the definition of building, which applies at the listing stage, and then what is a listed building subsequently. What is a listed building is then what is put on the list.
But still, there is no indication in the legislation that Parliament intended the Secretary of State to decide definitively what is a building. So that throws you back, I think, on the option of saying judicial review if you want to challenge it.
Yes.
And you don't pretend that it's the Secretary of State's discretion as to what is a building.
No, I sort of set a hair running, I appreciate, straight after lunch. It's the Secretary of State's discretion as to whether it's sufficiently special to warrant listing, but he's got to be satisfied that it's a building. Yes. Wicks, could I ask the court, please, to pick up volume 2, tab 22, 641. In passing, I just asked the court to note at 658, 1, 2, 3, fourth paragraph down, makes the point repeated by the House of Lords in Boddington that whether you're able to raise matter as a defence to criminal prosecution depends on the construction of the statute. That doesn't appear to be an issue.
I'm so sorry, where
It's the fourth paragraph down beginning, but my lords, while I'm willing for the sake of argument.
And I'm so sorry, on which page?
658.
658, sorry.
Yeah. And then you'll see about 5 lines down, that question must depend entirely on the construction. The passages specifically dealing with the enforcement powers at 660 to 661, and Lord Hoffman deals with the history of enforcement, and 5 paragraphs down says that the history shows that over the years there's been a consistent policy of progressively restricting the kind of issues with a person so that an enforcement notice can raise when he's prosecuted for failing to comply. He says there are 3 reasons. Firstly, unsuitability of the subject matter for decision by a criminal court. Secondly, allow for the validity of the notice to be conclusively determined quickly enough to enable planning control to be effective. And thirdly, to the fact that criminal proceedings are part of the mechanism for securing the enforcement of planning control. I draw the court's attention to that and the subsequent paragraphs down to 661. And he deals then with what he calls the residual grounds of challenge, which you'll see 3 paragraphs from the foot of page 660. He says the fact that residual grounds are not altogether excluded doesn't necessarily mean they can be raised as a defence to a prosecution. They may be available by other means. One has to ask why they were not included in the appeal procedure. The question, as it seems to me, is obvious. The question is whether the planning authority was motivated by mala fide's bias or whether his decision was based upon irrelevant or improper grounds, quite unsuitable for decision by a planning inspector. The question is whether then suitable for decision by a court.
I mean, that makes the point. The sort of issues which are not suitable for a planning inspector.
Yes.
But the question of whether something is or is not a building is perfectly suitable for discussion.
But the problem is if these issues are to be raised as part of an appeal process, then validity issues are not confined to issues just of whether it's a building or not.
Well, why not?
Well,
it's obviously a question of construction of the statute.
Well, that is true.
What's being put to you is this is inherent in the definition of a listed building that it is a building, as in the statute.
And I've made my submissions as to how that then is dealt with through the provisions. On the question of then how you deal with the matters not covered by the grounds of appeal, Lord Hoffman then reaches a conclusion about a third of the way, almost halfway down page 661, that criminal proceedings being part of the enforcement process are not appropriate for these matters to be raised. So
yes.
We simply say by analogy that applies here too. You've got...
But the Secretary of State makes the initial decision. This is a building. And so I would have thought that the Secretary of State, through the inspector, would be the appropriate first port of call for any objection by the owner. Look, you were wrong. This is not a building.
Yes.
It seems logical that it should go back in the first instance, subject to judicial review, to the Secretary of State by the inspector, he having made the initial decision.
Well, it then comes down to the construction of the grounds upon which an enforcement appeal can be brought, or an appeal against listed building consent.
Yes.
And we are supportive of the Court of Appeal's reasoning. The building is not a special architectural historic interest, is dealing only with the special interest aspects and is prospective only. And the contravention issue deals with the works on the assumption this is a listed building. I've made these submissions. There's no point in my repeating them.
No.
So I won't. But my submission is on the proper construction of the appeal provisions, and the same is true of the listed building consent provisions, section 21(3), that they are deliberately limited by Parliament. If Parliament had intended the wider question to be part of the appeal grounds, why did it not say so? And it's odd to say, to confine that the building is not, the ground to the building is not of special architectural historic interest, if the ground was in fact that the building was simply not properly listed, because that would encompass special architectural historic interest, or it would encompass the issue of building as well. But it's been confined to that, and we say it's clear from that, therefore, that Parliament clearly intended that it didn't go any wider than that. And that's a matter for the court.
Yes.
Can I just mention, at the risk of raising another hair, has anyone mentioned Article 8 of the Human Rights Convention? No. Because, I mean, it does seem slightly odd that you have presumably this obviously affects his private rights quite significantly.
You mean Article 6, my lord?
Yes, Article 6. I mean, does he not have a right to a fair challenge?
But as the House of Lords held in Alconbury, that Article 6 is vindicated by the availability of judicial.
Well, it was in that case, but it's a bit odd that he has his Article 6 rights are vindicated in this context by an appeal to the Secretary of State on one aspect of the decision, but not on the other aspect.
Well,
it seems a sort of unbalance.
Well, except, of course, that Alconbury concerned planning appeals and a compulsory purchase appeal. And that was in the context of issues that could be raised on planning appeals and judicial review.
Yes, of course. But there, that was held, he had the same rights in all. It wasn't a case where he had one type of right in relation to one part of the decision and a different type of right in relation to another. Anyway, so
without hashing over old ground, that all comes from Strasbourg authorities such as Zumtobel and the likes. I mean,
anyway, Mr. Howard hasn't gone down that route.
No, he hasn't. Can I come back to a matter that I didn't touch on before lunch when I was dealing with some of the questions from my Lord Carnwath, but the question of property interests property concepts was considered by Mr. Justice Bridge, as he then was in the Barvis case. If the court would please turn up Barvis, which is in volume 1. And it is tab 12, page 425. This was the case of a crane which the owners had decided not to keep on moving around but to erect on their own property. And the question was whether it was a development, and that turned on whether it was a building. Page 430. First main paragraph after about 15 lines down, the tests of the kind there suggested. This is referring to Woodward's case. And Mr. Justice Bridge says, I think one should avoid the danger of finding oneself in trying to solve one problem involved in the solution of another different problem. We've been referred in the course of argument to some of the decided cases in the field of real property law, deciding what do and what do not amount to fixtures. It would be quite wrong, in my judgment, to substitute that question for the statutory question, which is asked under the then 1962 Act. So,
I mean, this was the erection of a tower crane.
This was a crane which was mobile to a limited degree, as you'll see from the bottom of page 430, top of page 431, and the question whether it was development. But
But he says that, looking at this enormous crane, it seems to be impossible to say that it did not amount to a structure or erection. Good sort of common sense approach.
Well, my Lord Lord Wilson invited me to check that I had instructions to say that we say it's self-evidently a building in this case, and I do have those instructions to the extent.
It was Lord Carworth who asked for it.
I asked.
Was it? I
Yes,
do
and of
apologise.
course, I mean, in a way, it's irrelevant because obviously
Indeed.
they took that view, but it's being challenged, and
Indeed.
so we don't know what would happen if that was argued out. But
But sorry, going back to Barvis, so the property approach to buildings is rejected by Mr Justice Bridge. That's affirmed in the Skerritt's case by the Court of Appeal. Building, he then goes on to deal with, under what was then Section 221, same terminology as currently applies. He says includes a structure or erection. He then looks at the cases in the rating field on page 431 and cites the judgment of Mr Justice Jenkins in the Cardiff Rating Authority case. And it's important to note from that mobility, this is going to a point my lady raised with Mr Harwood earlier, the issue of mobility may be relevant, but it's not determinative.
Okay.
So just because you can move it around doesn't stop it being a structure. Yes.
Yes, that's the last sentence of
Indeed, and it's a point. It's a point which was picked up by the Court of Appeal in Barvis as well. So, Mr. Justice Jenkins has at least been approved at that level as well.
yes, I mean, good. I understand all that, but there's such different situations. See, because a large crane from an urn.
Well,
And I mean, are you going to deal with the sort of cases like Berkeley and Poulet? You just say that irrelevant to you.
they're irrelevant.
But I mean, they're at least. I mean, they're meant the ones mentioned at the end of Mr. Harwood's case, which is page 101 MS.
Indeed.
125, the marble statue of a Greek athlete weighing approximately half a
Yeah,
pound.
but the difficulty. I'm sorry, my lord. I don't mean to
And
interrupt.
the Henry Moore bronze sculpture, which weighing 1,500 kg, which is held not to be a fixture in Tower Hamlet's case. Now, I understand you reject that approach, but there must be some criteria, and if you're not going to adopt the traditional property law approach, there must be some other objective way of deciding what is part of the building, what is a building and what isn't. And you don't seem to be suggesting one. And you tell me there's no guidance at all from the Secretary of State.
I'm saying I've submitted there's no guidance from the Secretary of State or Historic England. I've made my submissions that it's not within the grounds open to an appellant to raise, for the reasons I've already stated and won't repeat. The cases such as Berkeley and Poulet and Holland and Hodgson and...
You say they're irrelevant.
They're-
So it all just depends on the say-so of the Secretary of State without any published guidance of any kind.
Well, it depends on a mixed fact and law.
I thought you were saying that the criterion is that which we get from Barvis and then through to Skerritt's, which is the particularly the formulation given by Mr. Justice Jenkins, which points to a number of factors which have to be taken into account.
Yes, I mean, that
As a
is that
holistic
your
thing.
case? I understood it was.
Well, we rather suggested, in line with the Court of Appeal, that those cases didn't assist.
Sorry, so Skerritt doesn't assist either.
Well,
What does assist?
Sorry, then I'd misunderstood.
Well, they're structures and buildings which the Secretary of State has a statutory duty to put into a list.
yes,
And we find elsewhere in the Act what the duty is.
yes. What we've said, I don't want to give a misleading impression.
Right.
We've said in 114 and 115 and 116.
Sorry, these page numbers.
Pages 129 to 30. You won't find it edifying from the point of view of the questions you've just asked me. We've said those cases are of limited relevance, as the Court of Appeal did. But if the court were looking for some criteria which it thought had to be applied, then those would be at least ones which are native to planning.
Yes, I mean, I
Rather
understand that. But they're dealing with a large crane and a marquee.
And there
We're
are
dealing with something completely different here, and which is terribly important because it affects, a lot of very important gardens, structures and so on.
War memorials.
And one needs to have some sort of sensible criteria so that people like Mr. Dill know what is like to be treated as a building and what is not.
Well, my lord, the problem is even let us suppose that one takes the Skerritts and Barvis line. That doesn't give you an answer to the question. It just tells you what the factors are.
But that's why you need guidance from the Secretary of State.
There is no duty on the Secretary of State to issue guidance. So, just as there's no guidance as to what a building is in terms of the building operations and the definition of development in the main act, what the courts have said is it's a matter looking at a whole series of criteria. You've seen what Mr. Justice Jenkins said. The Court of Appeal, Lord Justice Sheeman and Lord Justice Pill adopted that approach. It doesn't give you an instant answer. What it says is there are a series of criteria to have regard, to which one has regard. And neither mobility nor actual affixation to the ground are determinative of any of these matters. So if the court is looking for criteria to apply, as I say, at least these are rooted in planning authority under the main act.
And I thought it was the definition of building under the main act which we're told to apply.
It is. Section 91(2). It's fair to say that the cases that have concerned the issue of whether there's development and building operations, which then goes back to the issue of building, have concerned ostensibly temporary structures such as marquees. Polytunnels was one that Mr. Justice Sullivan had to deal with for fruit growing and the like. I'm not aware of them having been applied to something of this description. So all I can do is to say, well, if the court is looking for criteria, you have the general criteria, but they don't provide anything more than very broad outline guidance as to how you may approach the issue of building or structure. But still, it's then clear from both Barvis application of Jenkins and Skerritt's that it's still a matter of judgment for the decision maker. So in the first place, it's a matter of judgment for the Secretary of State, if necessary, applying those criteria, and therefore, if those matters are properly directed, then it's, except in cases of extreme cases, that it's still a matter for the Secretary of State to determine whether the relationship of the various factors means it's a building. It's not a clear-cut issue. Hence the mixed fact and law issue. So it doesn't give Mr. Dill an instant answer as to whether a 9 foot high.
As to whether it's been treated as a building. I mean, I can see if this had been sitting in Rest Park and was still there, probably would never have occurred to anyone that they would move it away nowadays. They might have done back in 1939, they did. But once it's been treated as effectively a chattel in the way this has, does that in any way affect the way you look at it?
No, because...
What do you say, no? I mean,
I was going to give a reason.
Yes.
No, because mobility is not a determining feature. And a lot, as the Historic England selection guidance has indicated, Historic England make it clear that a lot of ornamental urns, statuary and the like have been moved from their original positions over time and moved from properties to properties. If they are capable in law of being buildings and have historic or architectural interest, in my submission, it's entirely proper for them to be listed. The fact that they're capable of being moved can't be a determining feature as to whether they should be protected in my respectful submission, if mobility is not a critical determining factor.
I fully understand what you say about the test, that if
Yes.
one takes the test from Barvis being a matter of mixed fact and law and a matter of degree. You say that's a matter for the judgment of the decision maker, the Secretary of State. I can see that when the Secretary of State is asked to list something, he has to make up his mind, am I going to treat this as a building or
Yes.
not? But in terms of the statutory definition in section 1.5, in relevant contexts, it may be the court that's the decision maker as to whether something is a building. It has the statutory definition to apply. It has the guidance from Mr. Justice Jenkins and the other judges. And if it is right that the court has to look, for instance, in the course of a prosecution, whether there is a defence simply, this is not a building, why isn't the court the decision maker?
I'm just trying
Sorry.
to dig up Skerritt's again.
I mean, it goes back to the debate we were having before. My lady put to you, isn't the question of whether it's a building a question of precedent fact?
Yes.
Which is perhaps an equivalent way of putting to you what I'm seeking to put to you now as well.
The difficulty in my respectful submission is this, that because it's mixed fact and law, if the matter is to be approached broadly equivalent to the manner in which building is approached for the purpose of building operations under the Town and Country Planning Act to determine whether something's development or not, as it was in Skerritt's, it's still been accepted by the courts that the question of building involves a judgment by the decision maker as to whether or not it falls within the meaning of building. And I appreciate the outer limits of that must be controllable by the courts.
Well, but I'm putting to you a rather different point, that in certain contexts, the court is the decision maker. It doesn't have to ask the question, well, could the Secretary or did the Secretary of State reasonably draw the conclusion himself that this is a building? The court itself would be the decision maker, simply applying for itself the definition in section 1.5.
The difficulty with that, I suppose, would be that the court then has to find the facts.
Yes, it might do. If the defence is this isn't a building.
But the difficulty would be, let's take the criminal forum. The criminal court wouldn't be well equipped to do the exercise that you would do applying the planning definition, having regard to the criteria in Cardiff, Barvis and Skerritt's.
Right, I see. Thank you.
It would be, it's akin to the point that Lord Hoffman made in the passage I cited earlier. It's not an issue you would leave to the Crown Court.
So would you leave it to the planning inspector? That seemed to be Lord Hoffman's point, but you say not the planning inspector either.
I would leave it to the Secretary of State, subject to review and subject to control by the court, if he applied an approach to listing which was plainly contrary to the statutory definition. Because the Secretary of State still has to determine what factors go into listing, including the issue of whether it meets the requirements for building structure or erection. And normally that subject to him going wrong in law on directing himself as to what factors go into whether it's a building or not, would be subject to review only if it exceeded a reasonable assessment of the facts.
Yes, thank you.
The other concern is that if the issue it really is a public policy issue relating to the protection of listed buildings, which is this, that if the issue can be raised before an inspector on an enforcement appeal, there appears to be no reason why it couldn't be raised in other planning contexts as well. For example, on an ordinary planning appeal, where the presence of a listed building can be decisive in whether a planning appeal is allowed or refused. Section 66 of the Listed Buildings Act, which is in Bundle Volume 1, Tab 1, page 318, is the duty to have special regard to the desirability of preserving the building or its setting or any features of special interest, which has given rise to its own series of authorities as to how to deal with that. But the point is that it's clearly a highly relevant matter in determining planning applications and planning appeals. A local authority applying this has no recourse to making decisions as to whether something's a building or not. Yet, my learned friend's approach would allow it to be said in the course of a planning appeal that, well, it is within the setting of building X, but it shouldn't be a listed building because it's not a building within the statutory definition, and the Secretary of State got it wrong. appreciate it's a sort of variety of floodgates argument, but it's an important public policy one, given that we're protecting matters which are supposed to be assets of national importance. And that's my final point, really, in relation to why it's important to keep a tight approach to construing the grounds of appeal and whether these matters can be brought into play, rather than left to the Secretary of State subject to the control of the court if he exceeds what is lawfully a building, that it's there for the protection of these assets, and that allowing them to be raised in a whole variety of contexts gives rise to significant difficulties. If an authority is convinced, for example, on a planning application that the building ought not to have been listed because it's not a building, it's got no powers to do anything other than to say to the Secretary of State, we think you ought to reconsider the listing. It's not in a position to make any decisions one way or the other. And in my respectful submission, there are concerns about the extent of protection afforded to listed buildings if my learned friend submissions are accepted. So the public policy at the end of the day. Lord, can I check whether there are any other matters I need to go over? I did say to the court I would provide trim, which is my Lord Carnwath's judgment. I'm sorry, my Lord, I'm not using it in terror.
No, I'm intrigued to be reminded of it, so I haven't looked at it recently. But if you think it's relevant, it's all.
I put it in simply because my learned friend was relying on the Dill decision of the Divisional Court, Mr. Justice Sullivan, and this is your Lordship's response to that a few years later.
Okay.
It may or may not turn out to be.
No,
right.
I'll have another look at it for old time's sake. I don't think this case is going to turn on that somehow.
Well, it's a case where there are no rights of appeal at all. The contravention notice, breach of condition notices.
Oh, I see, yes. Okay, well then maybe we can go.
However, if your Lordship will forgive me,
Oh yes, this was a breach of condition notice. Well, that again was something that came out of my report, wasn't it?
it was indeed.
And I think I discussed then why I didn't think you needed to have an appeal provision.
Because it could be raised elsewhere.
Yeah.
I'm sorry, I'm lagging here, Mr. Elvin. Why are we looking at this case?
The reason you're looking at this is my learned friend relied on the Dill decision of the Divisional Court. In this case, the Court of Appeal, in the form of my Lord, considered that and explained as that the Court of Appeal did not think collateral challenges to breach of condition notices were permissible in civil stroke public proceedings.
I see.
And indicated the importance of public law defences and that the Administrative Court did have some ability to find facts.
Oh, right.
But it is, I mean, I think for myself, I don't think I want to find much help in it. But if anyone is looking at it, they should look at what I said about this in my report.
Yes.
Discusses the whole question of when you need at least I think I did, when you need an appeal right and you don't.
You did.
Yeah.
Yes.
Right.
That was merely for completeness.
Thank you.
Unless there are anything.
Well, can I just check where we are on disposal? If we were against you on the first issue, so that this was a matter which could be raised in enforcement proceedings.
Yes.
But as I understand it, you have submitted to us that it's clear that this item was a structure and fell within the meaning of building, and therefore it would seem on that submission that there isn't actually a defence available based on saying, well, it's not a building. Where does that leave us? Are you saying that we should dismiss the appeal? I'm sorry, I just wanted to see where we're going in terms of disposal on your case.
Well, you wouldn't remit it to the Secretary of State.
Sorry. Sorry. Is that a statement or a question? Sorry.
I mean,
If there was only one answer to the question, is it a building? That answer being yes, we wouldn't remit it.
No.
But you're not going as far as to say that no reasonable inspector could have said this, are you? I mean, are you saying that it's so obviously a building that any other conclusion was perverse?
Well, all I say is what I've already said. That the information, that there is limited information The Secretary of State reached the conclusion it was. We don't have the documents at the time. And in my submission, if the court came to it, it is self-evidently a building given its substance and its scale, and given its importance.
But you're not saying we should use that. I'm surprised you're saying that we should.
I've not run a discretion argument, no. But I was asked the question, so I answered it.
No, so you're not. So if we are against you on the question of whether it could have been raised for the inspector, you're not objecting it to being sent back.
No, but it may be a pointless exercise.
Right. Well, that's what I was asking. We know as much as any inspector will ever.
Well, which is why I showed you those three.
Well, that's why I'm asking you the question as to disposal. I mean, I suppose perhaps it comes down to is this: I can see if there's only one possible answer that anyone ever could give, then you're saying we should give that answer, and remitting it achieves nothing. But suppose that there are a range of possible answers, and that one could imagine different people doing different things, but we've got all the information that an inspector would have. Are you saying that we still remit even in those circumstances?
Well, unless the court thinks it's a fruitless exercise, because there's no point in remitting if the court thinks that the decision should be the same.
All right.
Yeah, but I mean, even if we have all the information the inspector has, we're not qualified to make a judgment about whether something should be treated as a building.
Well, which is why the difficulty with this case is the one the inspector identified, which is the items having gone. You're not able to assess any more than appears on the information he set out in his decision letter.
Well, I'm not sure the difficulty is that he decided not to consider that question at all. Anyway, there we are.
Yeah. Well, Lord, I'm not seeking to urge on the court that it ought to simply refuse. But if the court is of the view that it's a fruitless exercise, then of course that's a matter for its discretion in granting the disposal.
Yeah.
If, on the other hand, the court thinks that it is capable of more than one answer, then it must be remitted.
Yeah.
And it's remitted with the opinion of the court, so whoever redetermines it then does so in the light of the opinion of the court.
Philip?
Yes, I'm happy. Yes, thank you.
Thank you, my lord.
Mr. Elvin, thank you very much indeed.
Thank you.
Mr. Williams, give us 2 minutes, if you would like. Mr. Hunter.
Oh, yes, have the lecture. We have the copies of the form, by the way.
Thank you.
Yes.
Gary, thank you.
My lady, my lords, I'm going to address the bulk of my submissions onto the first issue. I have a few points to make on the second, but largely I will stick to the first issue. And delving into that, can I start with a preliminary point? In the council's written case, I've submitted, and I maintain the submission, that the argument for the appellant is equivocal. And the reason I highlight that is important in terms of the legal analysis. At times, the argument is put on the basis that the inspector was entitled to or required to consider whether the piers and urns were buildings as a matter of fact or on the merits. And at times it's put in terms of the inspector was obliged to consider that from the point of view of whether the Secretary of State's listing decision was invalid because of the judgment he reached on that. And I just highlight that. And I'm going to deal with them separately in that way. So the first argument, whether the inspector could decide for himself, as part of the appeals, whether the piers and urns were buildings. That argument turns on, is very clearly an argument of statutory interpretation because it turns entirely on the meaning of listed building in section 1, subsection 5. My lords, if I may just set out my position on behalf of the council as clearly as I can to start with. As Mr. Elvin said on behalf of the Secretary of State, in fact, the definition of listed building is simply a building which is for the time being included in a list compiled or approved by the Secretary of State. The deeming provisions do not identify the building, they identify things which are deemed to be part of the building. And what my overarching submission, in line with the Secretary of State, is that the decision by the Secretary of State to list under section 1, subsection 1, is determinative of the status of the thing listed as a listed building within the primary meaning of what section 1, subsection 5, but not determinative of whether anything else is to be treated as part of the building or part of the land within subsection 1, subsection 5b. Those are matters which clearly have to be addressed by looking at the facts on the ground. But that's the distinction I would draw at the outset. Well, it was put to my learned friend Mr. Elvin that it is clear that there are two elements to the definition. There must be a building and it must be listed. And indeed, I think the appellant's case is that the Secretary of State's decision on listing is determinative of its listing, or self-evidently, but not of whether it's a building. I would put the matter like this. It is a tautology to say that a listed building must be a building, but that isn't the issue. The issue is, firstly, who decides whether it's a building? We say the Secretary of State. And secondly, how and in what way may his determination on that be challenged? A further point is that the decision is a unitary decision. It is to include something on the list, but it has two elements, and to that extent I accept the points that were being put to my learned friend. The Secretary of State has to make two separate judgments. Is it a building, and should it be listed? Which will involve determining, taking advice from Historic England, forming a judgment on whether it has the requisite special interest. But once he has made that decision, it is the list which is determinative of both elements. So it's right to say there are two elements to it, but it's the Secretary of State who reaches a decision on both of them, and once he's decided them, and his decision is formally incorporated into an entry on the list, that is what is determinative of both elements. That's how I would put it. Of course, subject to the possibility of judicial review and to the Secretary of State himself amending the list. Now, that is consistent with, as I say, the position of the Secretary of State, both courts below, and it's also consistent with the authorities to which we, all parties have referred in their written cases. And unless your lordships wish me to take you to them, I will leave those as read. So these
You mean Lord Hope plus
Lord Hope, yes,
all that
exactly.
lot.
All that lot, which are
Not really focusing, as Mr. Elvin conceded, on this bare point.
they weren't conceded. I accept that. But it was at least assumed, whether or not the full ramifications were thought through, it may be open to question, but there is an assumption throughout that the list is authoritative and determinative, whatever exactly they may have understood by that. And it's clear that the appellant's submission deprives the list of that character because it is no more than provisional. It is open to question directly, he says, in an appeal under section 39 and possibly also under section 20. But in my submission, it goes further than that, and even perhaps further than it was submitted on behalf of the Secretary of State, because, and the reason for that is the fact that the argument boils down to the definition of listed building. Because if, in order for a decision maker, whenever it is relevant for a decision maker, whatever nature of decision maker it may be, to themselves consider the two separate issues, is it a building and is it listed? The listed part will be resolved by looking at the list. But if the decision maker themselves have to form their own judgment on whether it is a building, then that definition, that applies not just to an inspector dealing with a Section 20 appeal or a Section 39 appeal. It applies to every single proceeding in which the question of whether something is a listed building could be raised. So all criminal proceedings and all civil proceedings. And I say that because the definition in section 1.5 in terms says, in this act, listed building means. And there is no caveat, unlike section 91, which has the caveat, unless the context otherwise requires. There is this is a uniform definition to be applied throughout the Act. And so, as I said, my learned friend Mr. Elvin points out that therefore a planning inspector dealing with an ordinary planning appeal might be asked to reconsider whether the Secretary of State was wrong to list something as a building. Equally, as I say, it may arise in criminal proceedings if the appellant's submission is right. And if it arises as, in this context, as a matter of judgment for the criminal court, not a matter of reviewing the legality of the Secretary of State's listing decision, in my submission that has some rather unattractive consequences, because it means that it is something for the prosecution to prove, not the defence to establish to the civil standard, the prosecution to prove to the criminal standard. And so, as this case illustrates...
Why is that?
Well, because...
Someone raised the point, well, this isn't a listed building.
Because if listed building means what the appellant means in section 1.5, it means that in section 9 of the Act, which creates the direct offence of unauthorised works to a listed building. And so if I could just turn to that in tab 1 of the authorities, what it must mean is, looking at section 9, subsection 2, without prejudice, subsection 1, if a person executing or causing to be executed any works in relation to a listed building under a listed building consent fails to comply with any condition, he's guilty of an offence. Now, undoubtedly, even under the argument that I put forward and the Secretary of State puts forward, whether something is a listed building is an essential ingredient of the offence. But it's easily proved by producing the list, if we are right. If the appellant is right, all that the list proves is that the thing in question is listed, and the jury or the magistrate's court will need to be convinced to the criminal standard that it's a building. And that may not be problematic in many cases, but it may be problematic in borderline cases. And the court has been taken to, obviously this case is an example potentially of that, where people may have different views on whether the subject matter of this case are in fact buildings. But it also arises in other contexts, for example, the zebra crossing on Abbey Road, which is listed, all of the great variety of things which the Secretary of State and the Department have deemed, and Historic England in fact have deemed it appropriate to list.
Hang on a second, I'm not ready. Surely these are reasons for enabling it to be dealt with through the appeal process. But if it's something which could be raised by way of appeal, then you're protected by the section which says that the validity of the decision should not be questioned, the enforcement should not be questioned in any proceedings on any ground which could be raised on appeal.
My Lord, that is correct in the context of a listed building enforcement notice. Yeah. So when prosecuted under section 43 for non-compliance with a listed building enforcement notice, if that argument could not be run before a criminal court, my Lord is entirely right on that. But my Lord, that's why I took the court to section 9, because section 60...
It may well arise, but there's nothing equivalent. I mean, the fact that there's something specific in the Act which says you can't challenge enforcement notice on any grounds which you could raise on appeal,
yes,
would suggest that if there's nothing equivalent in relation to a prosecution, then you can raise a ground.
But my Lord, my point is the position would be different under a prosecution under section 43, where the preclusive provisions of section 64 would bite and prevent it being reconsidered by the criminal court. But section 64 does not apply to prosecutions under section 9. There are no preclusive provisions. That is
that's a deliberate choice of Parliament.
Well, my Lord, well, in that case, it would perhaps it would give a choice to a planning authority wishing to enforce, and the planning authority may wish to proceed under a listed building enforcement notice first. But the statute gives them the option of prosecuting straight away for a listed building offence without serving a notice. And if they do that, the burden would be on them, on the appellant's analysis, to prove to that standard, to a jury or to a magistrate's court, that the thing in question was a building. And any doubt which would arise, I would submit, in borderline cases, would be likely to be resolved against the planning authority prosecuting. And the danger, as Mr. Elvin pointed out, is the consequences that would potentially have in at least these controversial cases. It would be difficult to secure prosecutions or to be confident of securing prosecutions or convictions.
But I mean, doesn't that take you into the Boddington problem? I mean, that's direct application of the criminal law to someone where there may be, based on an administrative act, where there may be something wrong with the administrative act.
But my lord, that's why I drew the distinction at the outset between the two ways that my learned friend Mr. Harwood puts the argument. Boddington deals with validity. And if this is why I say it's different, if we are, the argument about the meaning of section 1.5 has these consequences. The argument, the Boddington argument, the invalidity argument doesn't, because invalidity, insofar as it may be a defence for criminal prosecution, is for the defence to prove to the civil standard. And it would be a question of law for the judge. It would be very clearly a question of law for the judge to decide, not the jury. And therefore, there are the objections to the second way my learned friend puts the argument are less in this respect. But if it's about the meaning of listed building, and if it is necessary to establish that something is a building in any proceedings where it may arise, I submit it has this consequence.
So one of the purposes of the Act then is to concentrate the challenges to building, if there are to be any, into judicial review.
My lady, yes, that's what that is my submission.
Because otherwise the planning system may start to fall apart.
My lady, that is the consequence of what I'm submitting. If I may, I won't address all the other points I've put in my skeleton now. They've obviously been covered already, and I'll just move on, if I may, to address a few points in relation to this issue raised by the appellant. The first one is the submission that I'm sorry, may I just go back one moment? There was
of course, Mr. Hunter, of course.
I said there are good reasons why, furthermore, why it should be seen to be the policy of the Act to make the Secretary of State the arbiter of this issue. The first one is that the duty to compile the list is imposed on the Secretary of State and the Secretary of State alone. No one else is given the responsibility, either as a duty or a power under the Act. The second reason is that he is the ultimate authority, in the words of Lord Scarman in Newbury, for the planning system generally. The third reason is that it's in accordance with democratic principle that the minister should be the one who ultimately decides which buildings are the ones which ought to be protected in the interests of the nation's heritage.
But they have to be buildings.
They have to be buildings, that's...
In section 1.5 says buildings, not in the opinion of the Secretary of State, a building.
No, I accept that, subject to the point made by Mr. Elvin, which I wholeheartedly agree with, that because there is an area for the exercise of judgment here, it's right that his judgment is the one that should be authoritative for the reasons I've given, and the further reason that, if I may just complete the iteration, he is also the only one who's under a duty to consult with Historic England before he makes any changes to the list. And that's obviously vitally important, because although Historic England's advice may largely go to questions of special interest, they also have expertise and knowledge of the types of structures that are involved and the classes of structure, and one sees that through the listing selection guides. So he is uniquely well placed, as well as having the responsibility of making this decision, to make or to be the authoritative decision maker in this respect. As I said, if I may just turn to a few of the arguments raised by the appellant in support of their construction of section 1.5. one argument raised is that the absence of a right of appeal against the Secretary of State's listing decisions or a review in England is a factor that supports the view that Parliament intended there to be a right to do so as part of the appeal process against a listed building enforcement notice. That is a counterintuitive and potentially perverse submission. The argument being that one can infer from the lack of an express right of appeal that there was intended to be an implicit right of appeal. And that is particularly so given that the Act did expressly confer a partial right to question the Secretary of State's listing decision on the merits, namely in respect of special character. And did so, in fact, in two places. So one has it in relation to an appeal against refusal of listed building consent and the provisions of Section 21(3), together with the power under Section 22(b), 1b, to argue that the building is not of special interest and it ought to be removed from the list, and the similar provisions in Section 39 and 41. In addition to that, if one looks at the terms of Section 39 and 41, and if I could just ask your Lordships to take up the first bundle of authorities, tab 1, page number 303, where we find Section 39.
Yes.
I appreciate this was it was read in a different way, I think potentially at least by the court earlier this morning. But in my submission, when one reads that as a whole, one sees that the status of the thing listed as a building is actually presumed throughout those provisions. So, to take one provision that was discussed earlier today, 1A, ground of appeal A, that the building is not of special architectural or historic interest. Well, in my submission, that is not apt as a vehicle for the argument that is advanced by the appellant. And I note that it wasn't relied on by Mr. Harwood, for the very reason that the way that it is drafted makes clear that it is not. It is that what is the subject of the notice is assumed to be a building, and the only question which arises under A is whether it is of special architectural or historic interest. And my Lord Calm was suggested that it could potentially be reinterpreted as if it said that the building is not a building of special architectural or historic interest. But I would submit that it's actually telling that it's not written like that.
But can I just ask you this? Or you can come to it. The Chambers case,
Yes.
where the issue is whether the pillbox is within the curtilage. Under which ground, first, do you accept you could raise that issue by way of appeal?
I don't disagree with it. I note the hesitation of Mr. Elvin to accept that it correctly represents the law.
So which ground does that come under?
That didn't come under any ground. I was going to come to that. And that was the context of that was an application for a declaration.
Yes, assume it's an enforcement notice. Someone's in response to an enforcement notice, they say this is not within the curtilage. Ground A or ground C?
Ground C.
Ground C.
And it's ground C, as I say, and that's why I said I accept that the listing is not determinative of whether something is part of a building within
And would you accept, therefore, that if he'd been prosecuted for damaging that listed building under Section 9, he could have raised by way of defence that it wasn't curtilage?
The prosecution would have to prove that it was within the curtilage and an ancillary building and so forth.
Sure.
Right.
But it would.
Can I just ask you in relation to that? Because that may be a question of fact and degree.
Yeah.
Just as whether it's a building in the first place. But you seem to be saying, when we were asking you questions about whether one could defend oneself by saying, well, it's not a building, that you couldn't because it's fact and degree and different people might come to different views. But that's equally true of the curtilage, but you say you can defend yourself.
Yes, but as I said, the distinction is, in the former case, one is questioning whether the thing that the Secretary of State has called a listed building and put on the listed building is actually a listed building at all. In the second case, when one is asking the court to decide whether or not it's part of a listed building within the deeming provisions, that is asking it to decide a question of fact which the Secretary of State's listing entry will say nothing about. So there is no contradiction there. The Secretary of State's listing description will not normally identify. It may. It's possible that it does, and that might be part of the evidence. But that goes to the deeming provisions, not whether the Secretary of State was right or wrong to identify a potentially controversial item, to use the neutral terminology, as a building to start with. So yes, there may be... There will be an infinite variety of cases. Some cases it will be very clear that it's a curtilage structure. Others it will be more debatable. But I said that doesn't raise the more profound issues as to the protection of the primary listed building, which arise from the construction that the appellant is advocating. Questions of whether the ancillary structure are of less significance than whether the primary listed building is in fact a listed building. Going back to the term, if I may go back to the terms of the statute. So, apart from section 39A, if one reads through the remainder of the grounds of appeal, again, I would simply make a similar point. I won't go through them. The court can obviously read them at leisure. There are constant references to the building which assume, rather than allowing it to be put in issue, that it is a building. And perhaps crucially, though, so the most important provision in this respect is the companion provision to the Ground A appeal, that the building isn't of special architectural or historic interest. So that is clearly the counterpart to that in the inspector or the Secretary of State's powers is found in section 41, subsection 6C. If he thinks fit, exercise his power under section...
What section is this?
Section 41, I beg...
41.
41, page 308.
Thank you.
But isn't this a two-edged weapon for you? Namely, that the Secretary of State can remove a building.
Yes, but I said if we look at the language of the provision, we see that this is directed to a situation where he is determined to allow an appeal under Ground A of section 39(1). So rather than that he has found that the building, in inverted commas, is not a building, because again, the language, he may exercise his power to amend any list compiled or approved under that section by removing from it the building to which the appeal relates. So it's again, when he removes it, there is still no... The statute assumes it is a building. So in my submission, that makes it clear that the ground on which it's being removed is not that it is not a building, but rather the ground set out in 39(1)A. My lord, my lady, if I may move on then to the invalidity argument, and if I can start by setting out an overview of what we say is the correct position. Firstly, the invalidity of a decision to list is amenable to judicial review. Secondly, but it is not a ground of appeal against a listed building enforcement notice. Thirdly, it follows that it is not caught by the preclusive provisions of section 62. So in principle, there is no statutory bar on it, no express statutory bar on it being raised in other proceedings. However, it cannot be raised in a criminal prosecution, or it's unlikely that it can be raised in criminal prosecution, although this issue does not strictly arise. I'd suggest it's unlikely it can be raised in a criminal prosecution for non-compliance with a listed building enforcement notice under section 43. And that is precisely because the provisions relating to listed building enforcement notices are very, very similar to the provisions relating to ordinary planning enforcement notice. So WICS applies. And the consequence of that, fourthly then, is that in the invalidity, saving for situations where there may be a nullity in the sense discussed in WICS, that invalidity apart from that is a residual ground that is confined to judicial review. And then the final point is to restate the position I set out earlier, but the position is different under section 9 because section 62, neither section 62 nor WICS have any application there. Section 62 doesn't apply because there's no notice, and for the same reasons, WICS doesn't apply because there isn't an elaborate appeal procedure. And so the principle in Boddington would apply there, most likely.
Doesn't it seem a bit strange? You can defend yourself in court on a criminal charge, but you can't defend yourself on the same issue in enforcement proceedings.
Well, is the answer to that you would apply for an adjournment of the enforcement proceedings while you went and saw whether you could get...
Well, exactly, and this is the point I'll return to, which is there is also, I think primarily the discussion has been on judicial review of the Secretary of State's listing decision. There is also the possibility of judicial review of the issue of the listed building enforcement notice itself.
But I mean, from your authority's point of view, surely it's much more convenient for these things to be dealt with through the ordinary planning and appeal procedure, which you know so well, and which is not going trotting off to the High Court all the time for judicial reviews. I mean, we want help from what's practical from your authority's point of view.
Well, my Lord, it may be possible to have sympathy with that view, but in my submission, that's not the question. It's the interpretation.
Well, I know we've got to do that. We've had submissions from Mr. Elvin on that, but you're giving us the local authority's viewpoint.
Well,
I thought you were saying that for the authority, you want a convenient, preferably cheap procedure.
Well, I will take instructions perhaps on what the authority would prefer, but my submission would be, it may well be that a local planning authority or some other body might want to write the statute differently if they were doing so, but that, it might...
No, but I mean, I assume you've come here with instructions and the authority decide it's worth spending money making representations to us. And so I'd have thought they would be able to help us in what they would like.
Well, my instructions are to present the matter objectively, and the authority has not... So my submissions aren't influenced by what might be the most convenient path for the authority, but it's unlikely to be the case because the argument, there is the permission filter in judicial review, so unmeritorious cases would be weeded out from the start, whereas if the matter can be raised within the context of a planning appeal, the authority will have to deal with it and address it in every case because there will be no filter. There is the risk of an inspector, not necessarily trained or in law, having his decision challenged subsequently in the High Court in any event. My Lord, so I'm not entirely convinced that it would necessarily be the most convenient procedure in any event from the local planning authority's point of view. In any event, the kind of issue that we are dealing with is not one that arises very regularly. I'm not aware, in fact, of there being another reported case exactly on point, although Mr. Harwood may correct me in reply. So these are comparatively rare cases which will arise where a challenge of this nature is brought.
Mr. Hunter, it is actually Harbour 3.
Thank you, Mark. I will My Lord, if I may have a few moments just to try and summarise the rest of my submissions.
A minute or two? Would that be fair?
I'm sorry, my Lord.
A minute or two, would that
Thank
be
you, my
fair?
My Lord, can I just make one further point? Then I will just rest with this. A further complication of the appellant's secondary argument, or the second argument, that invalidity can be raised as a ground of appeal is this. If that is right, so if an invalidity can be, the invalidity of the Secretary of State's listing decision is a ground of appeal, presumably under ground 3, on the basis that there can be no contravention of section 9 if the underlying listing decision was invalid. If that is right, then that argument cannot be raised in any other forum because of section 64. And that is at least paradoxical, because my learned friend's argument in relation to validity rests on, he said, the Boddington line of cases and the Winder line of cases, and the principles set out there regarding the presumption that the individual's right of access to the court to establish their legal rights and defend themselves will not be whittled down. But if my other friend is right and it can be raised on an appeal, it can't be raised anywhere else. So that means it can't be raised in defence to a criminal prosecution under section 43. It can't be raised in defence of an application for an injunction, should the planning authority do that. And perhaps most importantly, it couldn't be raised on judicial review. So if it's a ground of appeal, if invalidity of the Secretary of State's decision is a ground of appeal under section 39, it cannot be a ground for judicial review. Now, that may not... I anticipate it may be put that is not so problematic if it's just confined to this question of whether something is a building or not. But it's difficult to see how one interprets section 39(1)(c) if it embraces invalidity in any form as only embracing that one form of invalidity. But if invalidity as a whole is put within the scope of a ground C appeal, it is not possible to raise it in judicial review, which would be contrary to even more fundamental principles.
But why? If it's within the enforcement appeal, you have a fair opportunity to challenge it. You don't need judicial review.
Well, well, can I put it another way? If one, as this is a matter of statutory construction, in the end, one has to think what did Parliament intend? How did Parliament intend that the exclusive route to challenging a listed building enforcement notice on the ground that the Secretary of State's listing decision was itself invalid should be through an appeal to the Secretary of State himself? Or is it more plausible that Parliament intended that that should be a matter for the courts in line with ordinary constitutional principle, that they determine validity, the Minister decides the planning merits, and the Secretary of State decides validity. I'm sorry, Secretary of State decides the merits, and the courts decide validity.
But I mean, with respect, I don't want to take up further time. What cannot be challenged under the preclusive provisions is the validity of an enforcement notice. It doesn't tell you that you can't be prosecuted under Section 9, and if you are prosecuted, you can't raise a defence.
No, that's correct. But,
so I don't understand your point.
My point is that it would not be possible for for there to be judicial review of a listed building enforcement notice on that ground.
Yeah, but I mean, once you've had your enforcement notice, you've had your day in court.
But as I say, my Lord, that has a consequence. The issue of validity is left to the Secretary of State rather than the administrative court. And in my submission, that is not a plausible interpretation of the statute.
Right, okay, thank you.
Well, thank you very much indeed,
Thank you,
Mr.
Madam.
Hunter.
Thank you, my lady.
Very grateful. Yes, Mr. Underwood.
My lady, my lords, I want to take the points of issue 1 first of all, and then turn to issue 2. But we can, I hope, get to the heart of the matter my Lord Wilson said the question, it needs to be a building on the list. And what it is about in issue 1 is the process for making that determination as to where it's a building on the list. We have said, and my learned friends haven't disputed this at all, that the initial listing process is one that may well be unfair and it may well be ill-informed. Mr. Elvin accepted that sometimes owners might be consulted in advance of the decision to list, and sometimes they would not be. What the process needs to do is to find, ideally, a planning mechanism for resolving whether or not something is a building. And the legislation enables that to happen, because if it's not a building on the list, it's not a listed building, you don't need listed building consent, and that can be dealt with either in the context of a listed building enforcement notice appeal or in the context of a listed building consent application and the subsequent appeal. And the question there is going to be, is it a building? It's not a question of inviting an inspector to conduct a judicial review type exercise of the Secretary of State's initial decision, and the present case illustrates why that's not the best way of looking at things. If the inspector in 2016 was having to ask himself, well, what did the Secretary of State have in mind 30 years earlier when we don't have the file? Question for the Secretary of State and his inspector in the appeal process is it a building? And that's one which they are equipped to carry out that process of examining. It's not unusual for inspectors to have to deal with questions of law. It's not unusual for inspectors to have to deal with what really this is, which is a mixed question of fact and law. The cases we refer to are the question of validity of planning conditions, which inspectors and the Secretary of State have needed to deal with. The issue which my learned friends accept is established in chambers in Guildford as to whether or not a pillbox in the grounds of a listed farmhouse is part of the listed building by reason of section 5B. The issues which arose in City of Edinburgh as to what the interpretation of the list was. Those are issues which inspectors will often have to deal with and will often have to resolve and are well placed to seek to do so. The stage that follows, of course, the equivalent of judicial review in that process is the ability of participants to then challenge that decision and within the confines of legal review by application or appeal to the High Court pursuant to the Act. So it's a mechanism which works as a way of resolving those issues. Now,
Mr. Harwood, can you identify for us what the objections are to leaving it on the basis of a listing review request form, filling it out, getting a review of whether it's a building, and if you are dissatisfied with the review, taking it to judicial review? What's wrong with that?
What's wrong with treating that as the exclusive mechanism, which is necessarily my learned friend's submission, is that there is, first of all, there is no right to a review or a reconsideration. It's an exercise of discretion as to whether or not that process is undertaken. And the review form, which my learned friend helpfully passed up, rather illustrates that quite neatly, because that's not the form, which I mislay my copy, but because it's on the review process, which is the notes which my learned friend has passed up, It's a 28-day period from the decision to make that request for a review of a listing decision. If you're outside the 28-day period.
Sorry, so you're not talking about the form, but the Secretary of State.
It's a guidance, which is what we've...
For the non-statutory listing review, is that right?
Yes, which is what we've had passed up. I'm looking initially at the 2018 version, which is the one-headed... 2009 version. And thanks. That review process, the Miller & Friend says, is 28 days to make the request. If you're outside that period, there's not going to be a review in those mechanisms. It becomes, if the Secretary of State is prepared to entertain it, a fresh request for a listing or delisting or an amendment of the list. The grounds for requesting the review, where we do have under section D and E of the notes, do carry out as evidence the original decision has been wrongly made and give examples of significant factual error, irregularity in the process or new evidence. So it's not a mechanism for an entitlement review. It's not a mechanism where the Secretary of State has a discretion whether or not to review, but will carry out a review if somebody requests it. The Secretary of State's policy is to only allow a review in limited circumstances which are sufficient to trigger it where the request has been made in time. That's not a substitute for having the entitlement to raise the question when you are appealing on a listed building consent or appealing against a listed building enforcement notice, which is subjecting you to potentially severe consequences in due course. And my Learned Friends analysis is this problem. If the Secretary of State is, as Secretary Learned Friends now accept, able on a request, on a response to a letter, to ask, is this a building? Should this have been on the list in the first place? Which effectively must be the question. If you can do respond to request, there is no reason why that cannot be done in an appeal process. And where there is a linkage in the language about amending the list, it's an exercise, and the court has the references, it's an exercise in the appeal process of using the Secretary of State's power under Section 1 to amend the list. So there's no reason to confine it to informality. And of course, another difficulty with reliance on the informal process is another aspect of the Secretary of State's policy. The Secretary of State's policy not to consider delisting requests when there's a possibility of enforcement action being taken. The inherent premise of that is that delisting would be dealt with in the appeal process. And since this matter has come to Mr. Dill's attention, there has been the threat since 2015, ultimately carried out, of enforcement action following.
That's not inevitable. It could be the Secretary of State was simply leaving it to the defendant in the enforcement action proceedings to take whatever steps he was advised to take by separate proceedings to challenge the validity of the listing.
Well, the Secretary...
Yes.
The
mere fact that the Secretary of State won't reconsider listing doesn't mean to say there can't be judicial proceedings.
Well, a sensible way of looking at it is rather than go for the last resort of judicial review, and of course I emphasise many times that judicial review is a last resort, to go for a mechanism which seeks to, I said in the start of my reply, gets to the heart of the issue. The heart of the issue is this a building? It's not really a question. Ultimately, in 2020, It's not really a question now of what did the Secretary of State have in mind in 1986.
No, because it's a question of law, what a building
Yes.
is for the purpose of this statute. And whether the building in issue, the alleged building in issue in these proceedings fulfills the requirement of building.
Yeah.
So that would be a question of law. It's perfectly straightforward to deal with by judicial review. What's the disadvantage? Apart from the fact you've got two processes, but it's been explained, but maybe Parliament chose that deliberately.
Well, it's a question of law and fact. It does require
Well, judicial review.
factual decisions, and on some of these aspects is going to be affected in part by what view is taken on site, because that will be relevant in some circumstances. And putting in a mechanism and having a mechanism where the Secretary of State, through an appeal process, which, as has been pointed out, is usually a far cheaper and far more convenient method for local authorities amongst everybody else, to deal with that process, to sift that through. And then if there is a legal error in that decision-making process, for that then to be dealt with by the High Court, formally by an application or appeal rather than judicial review. But
It's by going by judicial review, you're cutting out that layer. You're straight into the system and up to the Court of Appeal and further. You wouldn't be going to have a hearing in front of the inspector, a report, a decision by the Secretary of State, appeal to the High Court, then Court of Appeal. Beyond.
well, you're
I mean, that's not
jumping into a more expensive stage of the process, and also, and you appreciate, a stage where there's a fact-finding process which is often going to be needed.
Yes, but the Administrative Court regularly does that.
The normal process in planning is for the thing to be sorted out by the inspector.
Yeah.
And if you have to go to court as the last resort, you do. But the idea that you should be shooting off to the High Court as your first port of call with respect seems...
I mean, it might be said that the planning appeal process is both cheaper and more appropriate in terms of procedure to deal with the very issue that is being said should be dealt with.
Yeah, yes, my Lord's right. And as an illustration, perhaps an even sharper issue altogether, the question of unlawful conditions is one which one might say is even more obviously suited to a High Court judgment than the issue which we have here. Yet it is well established, the decision of the House of Lords in Newbury, consideration of the Court of Appeal in Earthline, that is something which an inspector can and sometimes will have to determine. Of course, if it's got wrong legal terms, it will then go to the High Court. But we're all concerned to avoid having the lawyers stomping over the issues so early, and to try and resolve things before we have to get to the High Court level. Can I, if I may, just finish off on, I think, one...
But that may be a case where you're exercising planning judgment in the case of the validity of planning conditions.
No, my lady. It's there will be sometimes planning judgment as what conditions should be imposed or whether they should be changed. But
I mean, Newbury is about the validity, the
yes,
legal validity of a condition. And
indeed,
that was dealt with through the planning system.
it's whether it was lawful to put a condition on a previous planning commission quite a few years earlier, which would require buildings to be demolished once the temporary use had ended.
Right. Thank you.
The final matter I wanted to pick up on issue 1 is in terms of criminal prosecution, and Mr. Elvin referred to paragraph 73 of our statement, which is page 87, to say that we had said that where there was a building couldn't be raised in a section 9 prosecution. What we say at paragraph 73 is, moreover, as noted, Ms. Dill would like to be precluded from challenging the validity of the listing in a prosecution for failure to comply with the enforcement notice on the authority of Wicks. And that's on the basis that that's the section 43 prosecution, and the basis that the enforcement notice procedure is the one to have resolved that. That's all.
I mean, that's a prosecution for failing to comply with an enforcement.
Enforcement notice.
Not a prosecution for breach of for contravention of the list.
That's correct, my lord. If it was prosecution on section 9,
Yes,
then the question of is it a listed building
he could raise that.
could be raised. That's all I intended to say on issue.
I mean, do you agree that if he did raise such a defence, it would be for the prosecution to prove that it was a building?
Yes, as they would have needed to do if in the Chambers type case that issue had arisen. That's everything I intended to say on issue 1. Can I turn then to issue 2? And first of all, the Secretary of State's approach before lunch, when it was suggested for the first time that the Secretary of State had a view, in the context of these proceedings, that these were buildings, and Mr. Elvin sort of needed to take instructions over lunchtime as to whether or not, as I followed it, he ought to have said that. Now, that's not the way of dealing with these issues. The Secretary of State has had a good 4 years on these matters, and to throw out an opinion on the hoof without any reasoning, any decision making, is precisely the wrong way to go about it.
I wonder whether that's entirely fair. This case is all about whether there can be a challenge to a conclusion that these were buildings. It hasn't really been about the issue down the line, if there can be a challenge, what the answer would be.
It's because, well, we're going to what the question is on that. The fact of the matter is the Secretary of State.
In your position,
has
is if we're with you on the question of principle, whether it can be challenged, it should go back to the inspector to decide it. Is that your position?
My lord, it has to. The only powers which this court has are powers to quash the listed building consent appeal decision and send it back, and to remit the listed building enforcement notice appeal decision.
Yes, but you're not asking us to decide definitively that it's not a building, are you? I know you thought you'd like us to do that, but I think you're pushing your luck.
Well, my lord, I don't want to push my luck. Clearly, it would be remitted with the opinion of the court, and the reason for issue 2, of course, is for the court to consider what is the legal question as to what is a building. If, without seeking to push my luck, the court were to, on having looked at those tests, to be forming a view that this wasn't or wasn't likely to be a building, then that opinion would be gratefully received, but more particularly helpful in resolving a matter which, of course, from Mr. Dill's perspective, has gone on far too long. But all the court can do is to indicate where its mind would be going or would have gone. Ultimately, in that sense, it has to go back, but the more assistance, helpful. Can I then turn in the sort of the 5 minutes or so I have to what then?
You've got 10 minutes because we allowed Mr. Hunter another 5 minutes.
I'm obliged, Lord. I see where. In terms of the approach, and respect particularly Lord Sale's questions as to really why we are pointing ourselves towards the property tests. It's not simply a sort of picking up on whatever's conveniently lying around as previous legal tests, but to look at on the basis of statutory construction. If I can just take the court to our written case, and page 93. We start with the the general proposition that whether something is capable of being a building is a matter of statutory construction, and look at how that's been dealt with in some of the other contexts. And of course it is notable, this context, the courts have grappled with the consequences and have needed to read in beyond bare language of building structure or erection. So in terms of the latter part of 15b, paragraph 100, the Debenhams case dealing with the structures on that aspect of it, we should say that aspect of it, being ancillary to the main listed building. Then in terms of how that construction works, we deal with that at page 95. And pull together, particularly at paragraph 107, the features which show that a building forms part of or has the relationship with land. And I would add to that list the points which I made this morning about curtilage, about setting, about direct action going on the land, about the fact that the prosecution under section 44 for failure to comply with a listed building enforcement notice is against the owner of the land in those terms. It's tying that link into the relationship with the land. So we have to then ask, well, what is the relation? Where do we determine it's on the land or it's not? And in terms of the references to land and buildings, the reason why you have a reference to buildings is not that a building is something which does not have to be part of the land, that it's got some independent existence, so it's mobile, it's not fixed in. I'll come to this in a moment. But the listing regime is about buildings of special architectural or historic interest. It's not about land which does not have buildings which are of special interest. Those are subject to other regimes. So there's a separate statutory regime for registered gardens, which are of special interest. There's a non-statutory regime for a list of battlefield sites, which have historic interest, but they do not fall within the listed building regime because they are not buildings. It's a need for buildings, and it's a buildings on buildings, but the buildings have a connection with the land. And if we're looking in mobile terms in the examples which are thrown out more on the planning context, the crane in Barvis was running on steel rails which were embedded in concrete. It wasn't simply a vehicle in any sense, and of course would have needed to be dismantled. The marquee in Skerritts needed to be erected and taken apart, and all of the pieces that follow. But what we are dealing with here is not a 89-foot crane, nor is it a 7-bay marquee or acres of polytunnels for growing strawberries. It's dealing with a far more small-scale object, a garden ornament, in Lord Carnwath's words of ours. It's something which very naturally and in other cases has been looked at in the property law context. We've not turned it up, but Berkeley and Poulet, which is how they mention it's a case which, when you do land law, certainly in my day, it's the first case you get lectured on in land law. One of those issues was whether the 5 cubic weight statue of a Greek athlete on top of a plinth was part of the land or not. The Court of Appeal said it wasn't, although in that particular case the plinth was. That's the analogy which works in terms of analysing those issues, and whether it's the equestrian statue which is inside Scarisbrooke Hall in Cawthorne, or it's the large garden ornament which is outside Idlicott House. It's those assessments and those comparisons which help.
Well, most of those issues are going to be within 39(1)A, surely, whether they're special architectural, historic interest, the things like setting, where was this to be found, and so on.
Well, whether the special interest falls under 39(1)A, whether they are a building, the way we've approached that is to say, well, that goes to the contravention, that's C. Lord Wilson suggested this morning that actually it can be wrapped up under A in terms of the reference to the building. What matters is that it's dealt with within that process, and that's the useful means for achieving it. But on either of those approaches, the property law approach or the planning approach, as we put it, we're dealing with questions of permanence. And permanence, of course, works in different ways in different instances. What's notable here is that this is treated as recognised as a chattel. It's treated as an ornament. It goes around with the family. It's not part of the design. It's not there. It's not one of these things that's been with Idlicott since a son went on a grand tour in the 18th century. It's been moving around. It's been moving around and moved for the last time before listing, 13 years before listing. This is an exceptional case, facts. It raises issues which, as my learned friends have said, haven't been needed to be addressed by the court, but it raises issues which are of immense personal importance to Marcus Dill. He finds himself in a position with potentially very severe consequences in a situation where there is, on any view, a very real issue as to whether or not what he is being pursued for, what he is the subject of listed building enforcement notice for, whether or not that was a building in the first place. That is an issue which the Secretary of State has not dealt with, which Mr. Dill has raised when he was first able to do so, and it has still not been addressed. It should have been addressed. He was entitled to have it addressed. Were it to be addressed, at the very least, there is a very strong case that he would be right in doing so. So, my lady and my lords, I do ask you to allow the appeal, to quash and remit as appropriate on those decisions. If the court feels willing to give an opinion which is helpful towards where that result may well then end up. But to enable, from Mr. Dill's perspective, these matters to be satisfactorily resolved. Unless I can help the court any further, those are my submissions.
Thank you very much. As Mr. Harwood rightly says, these issues are very important to his client. We are fully aware of that. They also have a considerable general importance. They're also very interesting, and they're also very difficult. And we will take time to decide what our judgments should say.